we're now moving on to the last session before the lunch break. And let me introduce, I hope he's on Zoom, we have Kevin Langford, partner at Arthur Cox, specifically partner in the Arthur Cox Employment Law Group. Okay, I expect if you want to, there he is. Hiya, Kevin, can you see and hear us?
I can indeed.
Good stuff. I would say ordinarily for Kevin's time, you would pay about what, about €1 million a minute, Kevin? We have him for free. Don't lose this opportunity. Kevin is going to talk about the right to disconnect and the legal implications about that. Please, I want a barrage of questions for Kevin. His presentation, I understand, is around 15 minutes. Got 5 minutes for questions, Kevin. But in the meantime, please, over to you.
Afternoon, everyone, and hopefully everyone can see me and hear me. So I'm mindful that I'm all that stands between you and your lunch break, and that you've all been Zooming for the last few hours. So I do promise that I'm not going to be very long. I am going to share a screen with you. And I have a number of slides, but I will try and rattle through them quite quickly. So just bear with me. So I'm just going to look at the right to disconnect through a legal lens. And as I said, I'll avoid giving you a law lecture over the next few minutes, because I think that's probably the last thing you need before lunch. So just maybe to set some background context in relation to the right to disconnect. It derives from the Making Remote Work government strategy that was launched back in January, which had 3 pillars, one of which is to create a conducive environment. And essentially there were 2 sort of substantive objectives under that pillar. One is the legislating for the right to request remote work, which hasn't happened yet. The second was to introduce a code of practice on the right to disconnect, and that has happened, and happened in Q1 this year, which was the objective set out in the strategy. So it followed a public consultation process, and there was engagement with the social partners in the normal way. And then our Taoiseach signed the code of practice on the 1st of April. It applies to all types of employment, all types of employees, whether you're working in a fixed location, remotely or otherwise. So what is it? Well, the reason for it is set out in the code, and it's on the slide. The Taoiseach said when he launched it on the 1st of April that it's all about work-life balance. Now, I know Siobhan told you that work-life balance is a myth, and maybe the better word for it is detachment, which I think was Siobhan's word. But essentially, there are 3 core elements to the code, 2 of which are rights and the other is a duty. The main right is to not have to work outside your normal working hours on a routine basis. The secondary right is not to be penalized for refusing to do so. And then there is a duty or an obligation on employees to respect the right to disconnect of others. The code is underpinned by references to 4 main pieces of legislation, and 2 of which I think are worthy of mention at this point. The Working Time Act, which, as you know, imposes obligations on employers in relation to maximum weekly working limits, daily rest, rest breaks, lunch breaks, etc. And the code makes reference to the Act, and I think we can all agree that in circumstances where our workforces have been operating mostly at home over the last couple of years, that the implementation of the Working Time Act is a lot more challenging, because essentially employees are effectively setting their own patterns of work. How do you know if your employees aren't taking their lunch breaks? How do you record working time when people are working from home? So the right to disconnect has become more challenging in that context. The health and safety legislation is also worthy of mention, because there is a very strong health and safety focus running through the code. And the employer's main obligation under Section 8 of the 2005 Act is specifically called out, and that's the duty on an employer to manage and conduct work activities in a way to prevent any improper conduct or behavior likely to put the safety, health and welfare at work of employees at risk. Reference is also made to the obligation to review your risk assessments and indeed your safety statements, because your safety statements are supposed to be reviewed at least on an annual basis. But in the context of the right to disconnect, this just gives an extra dimension or something else to be looked at when you are updating your safety statements. And then finally, in relation to health and safety, emphasis is placed in relation to penalisation or non-penalisation, should I say, of employees. And there's a specific prohibition on that in section 27 of the 2005 Act. The code outlines a number of employer obligations, and again, they're set by reference to the pieces of legislation that I mentioned earlier. Apologies. In fact, I'll just move on to the employee obligations. I'm just conscious of time. So just turning to the employee obligations, there is mutuality of obligation here. So a number of obligations on employers, but equally employees have responsibilities too. And they're called out in the code. One of which, again, in a health and safety context, and which is often overlooked, is that employees themselves have a statutory responsibility to take care not only for their own safety, health and welfare, but also that of their colleagues. I think it's also worth calling out in relation to that slide, the bullet point which obliges employees to notify employers of, in writing, of any rest periods or breaks that they were unable to take, and not only that, but the reasons why. So there is a strong thread of cooperation from employees running through the code, and it's just important not to lose sight of that. So the code recommends that employers have a policy on the right to disconnect, and there is a sample policy set out in the code. And I've just set out on 2 slides, by reference to 4 headings, some general principles which should be incorporated into into a right to disconnect policy. And just to mention, just to call out some of them. So the general principle is that there is an expectation that staff are not required to work outside of their normal working hours, but there are, like a lot of things, there are exceptions. And the code does envisage occasional legitimate situations where employees can be contacted out of hours. And for example, that might be contacting them to ascertain their availability to work certain rosters, or to fill in at short notice for a colleague who's out sick, emergencies, unforeseen circumstances, etc. I'd also make mention of the reference to a time management system, and I touched upon that earlier, particularly in the context of remote working. The code does say that it is advisable to have a time management system, and particularly mentions that in the context of remote or flexible working. Just in relation to communications, one of the points that I mentioned there is the whole issue of meetings. I think we all have meeting fatigue these days, because it's so easy to convene meetings, having regard to all the digital platforms that are out there. And the code notes that employees should only be invited to meetings where they play an active role and have something to contribute. So it's something to bear in mind. So just the other 2 points in relation to a right to disconnect policy. The role of the manager is an important one. And there is a responsibility on managers called out in the code, and that is to ensure that employees are set clear goals and deliverables that are achievable in normal working hours. So that's a positive responsibility that's placed on managers, you know, when setting objectives and goals for staff. Just in relation to culture and oversight, just a few quick points there. The code does say that the policy should be referenced in individual contracts of employment. Now, I'm not suggesting that you need to amend individual contracts of employment to make reference to the policy, but in relation to the issuing of contracts to new employees, reference should be made to the policy. There's also a suggestion that employers might consider establishing a monitoring committee to oversee implementation of the policy, or if not a committee, to assign responsibility to a specific HR staff member, as if you haven't enough to be doing already. So just then looking at the issue of raising concerns and grievances arising from the right to disconnect. So there's 3 examples on the slide of situations where employees may raise concerns. Just on the third one, which is being penalised for not being available out of normal working hours, or to put it another way, if other employees who are available are receiving more favourable treatment. The code does mention in particular the whole importance of equality proofing a right to disconnect policy to ensure that those who have carer or family responsibilities, etc., are not treated less favourably in this context. Now, the code also recommends a 3-step process for handling concerns or grievances. In the first instance, an informal process. If not resolved, then utilise the formal company grievance procedure, or indeed any grievance procedure in collective agreements. And then finally, referral to WRC under appropriate legislation, e.g. the Working Time Act, and citing the code. So what if you don't comply with the code? What are the consequences? I suppose the first point to make is that a breach of the code is not an offence in itself, nor does it entitle an employee to any specific amount of compensation, or indeed any compensation. However, a breach of the code is admissible in evidence, and that's clear from the Workplace Relations Act. So the WRC, for example, hearing a Working Time Act claim, or the Labour Court, or indeed perhaps the civil courts hearing maybe an employee stress claim or something of that nature, could take evidence or hear evidence in relation to alleged breaches of the code, and they would be taken into account. I was just going to touch on a couple of case examples in relation to the area in particular of employees working in excess of their working of the maximum permitted working time. And these 2 cases have relatively similar fact patterns but different outcomes, both the Labour Court. The first one is the KeyPack case, and in that particular case, a business development executive brought a claim under Section 15 of the Act, claiming that she had routinely been asked to work over 48 hours a week. And she won before the WRC. Both parties appealed to the Labour Court. And the Labour Court effectively upheld the claim and awarded her €7,500, which isn't an enormous sum of money. However, there's one important point coming out of that case, and that is that Miss O'Hara had produced in evidence a number of emails which showed, the emails that she had sent and or had received at all kinds of hours of the day and night, and the employer had no evidence to counter that, and had no records to rely on. And Section 25 of the Working Time Act obliges an employer to keep records of working time for 3 years, and that also applies, by the way, in a remote working context. And what Section 25 also states is that if the employer doesn't have any records, then the onus of proving compliance is on the employer. So hence the importance of records. And then in the other case, very briefly, a different outcome. The claimant was a French language telesales specialist. Again, a claim for breach of Section 15 of the Act, working in excess of weekly maximum working hours. And she was unsuccessful before the WRC, appealed to the Labour Court, and the Labour Court perhaps took a more pragmatic approach. The employer admitted that the employee had worked excessive hours, but had maintained in evidence that she had not been required to do so and had been discouraged from doing so. And the court ultimately found that the breach was technical and non-culpable in nature, and the claimant was primarily responsible for the situation in that particular case. So I do envisage a lot more of these types of claims in the future, given that the right to disconnect code has only come in this year. So finally, we're not the first jurisdiction to implement a code. I think the first movers were the French, who amended their labour code in 2017 when they introduced a requirement for employers with over 50 employees to set down specified hours when staff should not engage in work-related emails. And I've outlined in the slide a number of specific examples of where employers have introduced certain mechanisms, I suppose, to discourage excessive working hours and to encourage employees to disconnect. I like the OLARC one in particular, where you get $1,000 if you can if you can go on vacation for 5 days without checking in or answering your emails. It's more difficult than it sounds. So on that note, I'm going to pause at this point, and if anyone has any questions, I'd be happy to answer them. Thank you very much.
Thank you, and thanks for going into detail on the code there and giving us practical examples. Your examples, unless I'm mistaken, come from the private sector, and I'm just wondering, people listening in, you know higher education is one of your areas of expertise in terms of employee law. We are a very highly regulated sector, heavily unionized, with a lot of employee protections. So could you give a sense where maybe we as a sector, the higher education, might be more exposed, let's say, in terms of the right to disconnect code? I don't think the public sector is, and maybe those attending might take a different view. I don't think it's necessarily more exposed or less exposed, and perhaps there isn't the same element that exists in some private sector employments where you have multinational employment, and there's the whole issue of global time zones and people having to work late because they have to deal with, colleagues in the US and so on. But I mean, I think it certainly strikes me, as having operated in this space as an advisor for a number of years, that certainly the days of public servants working 9 to 5 are long since gone. And I find myself dealing with clients in the university sector, often late into the evening. And so I think a lot of it really, whether public sector or private sector, as I mentioned earlier, a lot of it, I think, is down to the fact that when people move, I think it's two things. One, everything is just getting busier and busier. Everything is getting more urgent, and things have to be dealt with. But also, I think the second point, then, as I mentioned earlier, is the working from home. Everyone has set their own pattern of work, that leads to all kinds of consequences. It's just very difficult to keep track of the hours that people are keeping. Thanks very much, Kevin. I think we may have time for one more question, sadly, and I'm not surprised that Elizabeth picked up on your reference to emails late at night in the it was the KeyPack example. And I know in our university we have been developing, or we have published a good email etiquette guide, but Elizabeth gave the example here of the use in email signatures saying, explaining that they don't expect answers, let's say, outside of normal working hours. Is that enough? Does that cover us? Just that kind of light touch?
I don't think it's enough, but it's a good start. I mean, I think it's like a lot of these things. It's kind of the more proactive steps to take, the better. It's certainly a very good start. I either to delay sending your email or to put in those kind of messages, or even in a specific email to say, I'm sending this now because it suited me, but I'm not expecting you to respond, until your normal working hours. But I mean, that certainly helps, not the only thing. I mentioned earlier, for example, the responsibility of managers, which is built into the code, to essentially proactively, set goals for staff that are achievable within normal working hours, to keep an eye on their staff, to keep, look out for signs, to keep checking in with your staff, particularly in a remote context. I think that's certainly something where there's a greater responsibility to check in with people, so it's not out of sight, out of mind. So to answer your question, certainly very helpful, a good thing to do, but it's one of many things I think that needs to be done.
Kevin, thank you so much for your expertise today and for sharing your time with us. I really appreciate it on a really important matter. I'm going to pick up on the right to disconnect and encourage our delegates to disconnect now, because we're about to take a lunch break. We'll be back at 1:45. I will be donning my top hat in the second half because we've got some spot prizes to give away. We'll be spinning the wheel, Marty Whelan style. But in the meantime, please disconnect, have your comfort break, have your refreshment, and we'll see you back at 1:45. Thank you very much.